Hi everyone, how are you all today? I am here as promised, coming to you from Auckland, where I am attending the Australian College of Strata Lawyers annual conference, 14th annual conference. And yesterday I took the stage and presented on the topic of short-term letting. What does the legal landscape look like across the country when it comes to the regulation of short-term letting in our strata buildings? Now, I was actually invited to present this year because I did a more detailed paper last year for the college, and that more detailed paper looked at all the different ways that our various states in Australia regulate short-term letting and what is happening around the country on that hot topic. So this year I was presenting an update, and as well as speaking, I have produced a detailed paper. This is it. 10 pages, and I am going to make that paper available to members of the Your Strata Property online community. I'm going to upload that into the member portal, and our members can take a look at that. The 2018 paper is also in the member portal. If you are not a member or you're not sure what membership is all about, you want to head over to the website, yourstrataproperty.com.au, and you'll find out some information there about membership. And yes, you'll see that membership is currently closed. And I urge you to get on the waiting list for membership, because there'll be a little something happening very soon for those people who are on the wait list for membership. If you want to jump straight on there, you just head over to yourstrataproperty.com.au/join. So members will be having access to the more detailed paper, but a number of you asked if I could share my insights for you from this conference, particularly in relation to my presentation. So I have just ducked out, and I'm going to take a few minutes or so to fill you in on what I spoke about yesterday when it comes to short-term letting across our jurisdictions. So I focused mainly on New South Wales and Victoria, that being the area where we've seen most action in the last 12 months when it comes to short-term letting. So what is happening in New South Wales? Well, our government has decided that it should take a whole of government approach, they say, to regulating short-term letting. And the way they're doing that is with a three-part framework. The first part to that framework is the code of conduct. And this is probably the thing that you're hearing the most about in the media, the code of conduct. What is it? Is it going to solve all of our problems? Is it going to keep all of our residents happy? The code of conduct is referred to in an amendment to the Fair Trading Act. So the code of conduct is not actually going to be mentioned in the Strata Schemes Management Act. It's in an amendment to the Fair Trading Act. And that amendment has actually already been passed by our Parliament. It just hasn't commenced yet. Why hasn't it commenced when it was passed about 6 months ago? Well, it's because we can't really decide what is supposed to go in the code of conduct, or maybe we can't agree on what is supposed to go in the code of conduct, not to mention the fact that in New South Wales we do have a state election coming up later this month. So nobody's really committed or able or perhaps willing to settle this issue at the moment. But if you go over to Fair Trading's website, they do give some indication of at least what Fair Trading says should be, or they plan to have in the code of conduct. And it's going to contain things like a 2 strikes and you're out policy. So hosts or guests of short-term letting who commit to serious breaches of the code within 2 years, it's proposed that they would be banned from engaging in any short-term letting for a period of 5 years. The code is also proposing to establish a complaints system, so making those records of complaint available to neighbours, to strata communities, to owners corporations to be able to make those complaints and have them registered. It says that complaints will be assessed by independent and impartial adjudicators. And the complaints and the strikes will be recorded on an online register. So that is designed to prevent guests or hosts from platform shopping. So if you've been banned from Airbnb, you can't then go on to Stays or some other website because you're on the register. Now, none of this is a given. All of this is proposed, and some being supported by our owner advocacy groups, other parts not supported, and looking for more interventionist approaches. But at the moment, really, it is all up in the air. Thank you, George, for the thumbs up. Lovely to see you here. The code has not been settled. Still debating, still discussing, and we wait and see what happens there. What has been settled is the second part of the framework, which is an amendment to our Strata Schemes Management Act. And this amendment is to insert a new section in our Act in New South Wales, section 137A. Now, I say that this has been settled, this is going to be the law, but it hasn't started yet. It's not the law right now, but it's definitely been passed by Parliament. So new section 137A, in short, says that an owners corporation can make a bylaw that prevents an investor owner, someone whose lot is not their principal place of residence, it prevents them from short-term letting at all. So we're going to have in our Strata Schemes Management Act a very clear section that says we can make bylaws that prevent investor owners from using their lots for short-term letting. Okay, so some clarity there, which we've all been begging for, is on the way. Now, this needs to be considered before you all go off, start drafting your bylaws preventing owners from short-term letting. We need to consider this hand in hand with the third part of the framework, which involves changes to our state planning law. And this is the part of the framework that is going to deal with resident owners who are short-term letting. So you might have a resident who rents out a room on a short-term basis, or more likely, you've got a resident that wants to short-term let their entire apartment while they are themselves overseas. And they might be overseas for part of the year, short-term letting while they're away, and then they come back. Now, our planning law, not our Strata Act, our planning law is proposing to deal with those owners. And the proposal from the planning department at the moment is that resident owners would be permitted to short-term let their properties a maximum of 180 days per year. Okay, so if you're a resident owner and you want to use Airbnb or short-term letting while you're away, the planning law is proposing to cap you at 180 days per year for your short-term letting. So that's not going to be in the Strata law, it's going to be in the planning law. The Code of Conduct is not going to be in the Strata law, it's going to be in the Fair Trading Act. So a little bit complicated, but that's what I mean when I say a whole of government approach. And we're going to have to be really across this when it all starts. None of it has started yet. The planning law is still a proposal. The Code of Conduct is still a proposal. The Strata law, new section 137A, is settled. That is what it is going to say about prohibiting investor owners with a bylaw, but it has not yet started. All right, so that's New South Wales. Victoria, there are some things happening there. They have just started with a new set of laws which deal with short-term accommodation. Their new laws started on the 1st of February this year, just last month. And the details about their laws were set out in my 2018 paper, which I've said is available to members. But in short, the law in Victoria is not placing any restriction on the practice of short-term letting in strata, but basically they're giving greater powers to regulate the outcomes of short-term letting. So when it comes to noise and damage and complaints, they're giving their tribunal, VCAT, greater powers to award penalties and higher penalties. So if you're in Victoria, this is new law that has been inserted into your Owners Corporation Act. And we wait and see how Victorian residents and practitioners and owners use these laws, whether they work, whether they help to address some of the concerns that people do have with short-term letting in that state. Now, particularly interesting to me is a case that came out of Victoria towards the end of last year. I think it was December 2018, and I spoke about this to the college yesterday. That case is called Lim. And this case really shows the creative steps that are being taken by some buildings to limit the impacts of short-term letting on their properties. It's Lim and the Owners Corporation PS 714612M. Okay, that's what the Owners Corporation's number is in Victoria. Now, in this case, Mr. Lim complained to the tribunal that the tenant directives that the Owners Corporation had adopted under their bylaws, they call them rules in Victoria, the tenant directives were prohibiting him from letting out his apartment to short-stay tenants. Now, this building had a set of directives, basically a procedure, a policy adopted in their bylaws that each tenant had to go through in order to comply with the rule and be able to get their security fob and be allowed to stay in the building. And they called this an induction process, and it included things like giving 72 hours notice of an intention to move in. The move-in had to be on a weekday between the hours of 9 and 5, so it could be supervised by the building manager. And if the tenant wanted to come in after hours, then the owner had to pay a fee of $300. So some pretty onerous requirements there. And the owner, Mr. Lim, got a little bit frustrated with the Owners Corporation and decided to go to the tribunal and say, hey, I don't think this is fair, and this is really infringing on my ability to be able to have short stay tenants, because obviously I've got to pay all of these fees. People don't really want to stay when they need to go through an induction process, and I have to give 72 hours notice. Well, the tribunal said, I don't have a problem with these tenant directives. Don't see a problem. The Owners Corporation can make these rules. It makes sense that if there is an additional cost for after hours attendance by the building manager to let somebody in and to take them through the induction, then there should be a fee. And the tribunal didn't think it was unfair that Mr. Lim was paying those higher fees. They said, well, buddy, that's your choice. If you want to do short-term letting and you want to have lots of tenants coming and going, then you're going to have to go through this process. Now, one interesting thing that came up in that case was that the Owners Corporation had actually deactivated a security fob for one of the short-term tenants. And they did that because they said that the tenant was in breach of one of their rules, one of their bylaws. And the tribunal was very clear that the Owners Corporation was not allowed to do that, was not allowed to prevent access to the building by a tenant just because they were in breach of a bylaw. So very interesting point there coming out of the Victorian Tribunal. But I do wonder, if other buildings, not just in Victoria, but in other states, are going to have a look at these opportunities to otherwise regulate short-term letting and the impacts of short-term letting by using some creative induction processes, some charging additional fees for building management services, for perhaps strata management services, where we've got lots of short-term tenants coming and going, and this case does give support for that kind of approach. So I do wonder if we're going to see some more rules and some more bylaws that look like that, particularly as we're waiting for our legislation to catch up with the modern world, perhaps. Now, in my paper, I do have a look at Queensland, at Western Australia, at Tasmania as well, and the few things that they're doing. Basically, everybody seems to have an inquiry going on or some kind of standing committee looking into the regulation of short-term letting in their state. Tasmania has a draft bill that is before their parliament. And very interestingly, Tasmania remains the only Australian jurisdiction in which there is a clearly legislated position on the way strata properties can use bylaws to regulate short-term letting. So they've got this section 91 in their Strata Titles Act, which specifically says a building can have a bylaw that imposes a minimum term, but that minimum term can't be any more than 6 months. So in Tasmania, you can say nobody can come and stay here for less than 6 months. So no other Australian jurisdiction has strata law that says that. So Tasmania maybe a little bit ahead of the game there, at least in the way of being clear about what the rights of buildings are when it comes to making bylaws about short-term letting. So that is my update on what's happening with short-term letting across Australia, most parts of Australia there. As I mentioned, if you want to grab a copy of the paper from last year or this year's paper, it is available to members. I know there's a few of you on this page. Hello, hello, inside the Your Strata Property online community. And if you're not a member, jump on the wait list. Now is the time. yourstrataproperty.com.au/join. Lovely to be chatting with you all today. I hope you enjoyed that. Let me have your comments, questions. I'm sure after a long life like this, there will be questions. I look forward to them. See you guys.